Now, if you ended up with a judgment against you, sometimes people have a look at their credit scores and go, I've got CCJ against me. You might be wondering how it's happened. So when a claim form is served, the person has 14 days to acknowledge service. And as long as they do, then they can have up to 28 days in total in order to file the defense. If you fail to do one of those things, then you end up with judgment against you if the claimant applies for it. Now, quite often people will say, I didn't get it. What's this about? If you genuinely didn't receive the claim form, and let me say genuinely, don't you received it and you ignored it, then that's a different matter. It doesn't necessarily mean that you weren't deemed served. All that needs to happen is that the claimant, or in most cases actually the court, took the step necessary in order to get it served upon you. That's usually just sticking it in the post box. As long as it can be proved that happened, there is what we call regular service, which means that you're in the hands of the court's discretion about having it set aside. If the claimant can't prove that it was served, either because they're required to do it themselves and failed to do, or because the court failed to take an administrative step to have it served upon you, then you can have it set aside on what we call the mandatory ground. It will be set aside as a matter of course. But in either case, you do have to apply. If you are applying to set it aside on the discretionary grounds, you have to not only show that you have a real prospect of successfully defending the claim, because otherwise why bother setting aside the judgment at all, you also have to apply for what's known as relief from sanctions. Relief from sanctions requires the court to consider, was the breach serious and significant? It always is. Filing a defence is a serious breach. Secondly, was there a good reason for it? That will depend. And thirdly, consider the justice of the case in order to decide whether to set aside the judgment. Again, that will depend. Get advice on those things. But most importantly, you've got to do it promptly. That is a requirement under the rules. So if you wait probably more than about 4 weeks, you're going to be at risk of being found to have not acted promptly. And then even if the other circumstances are met, that you've got a real prospect of successfully defending, and you can show that you should have relief from sanctions, you may well find that you are going to get your application refused. Get advice early. You can do it yourself, but it's one of those things that if you don't get it right, you only get one shot at it. And if you get it wrong, then you're going to be stuck with the judgment. So good to get advice, good to get someone to do it for you. And if you need us to do it, reach out, pinpointlawyers.com.